Welcome to Dorsey and Whitney's Advertising Law Basics, Part 3 webinar on influencers and other social media advertising issues. I'd like to introduce Charlene Krogh, a partner in Dorsey's Trademark, Copyright, and Advertising Group. Charlene?
Thanks, Sean. Hi, everybody. Good morning or afternoon, depending on where you are. Thank you for joining us for the third and final session of our three-part series on advertising law basics. Today, we will discuss legal issues with influencers and other social media advertising. A couple of housekeeping issues. First, the program is 60 minutes. Materials and attendance form are available for download from Dorsey's reminder email. Return your completed attendance form to the attendance@dorsey.com email address. We will use the chat for questions. We'll definitely try to get to them throughout the presentation. Please feel free to post. If we can't get to them for time reasons, please reach out to us. Our information is at the end of the slides. Love to continue the conversation with you. Also, we'll have a few polls during this webinar. In the interest of time, we'll move pretty fast through them, so try to answer as quickly as you can. We'd love to get everybody engaged on that. Dorsey speakers, you heard me. I'm a partner at Dorsey in the Denver office. For those of you who have been with us for the other two sessions, you'll remember Fara. She is a partner in the New York office. And then new to these sessions is Tim Carter out of our Minneapolis office. We're super happy to have him here. All right, let's get started. Let's talk about influencers, who they are, what they do, what they have to do, where they have to do it, when, why, and how. Fara's gonna kick us off. Tell us who influencers are, Fara.
Great, thanks, Charlene. So welcome everybody. So when we talk about influencers, we are talking about your typical influencers that you guys probably all think of and recognize, or brand ambassadors, if you will. But we're also talking about, different kinds of influencers. They can be bloggers. They can be, obviously, reality TV folks do this in their probably most of their time. Gamers is another big category of influencers that I think folks don't normally think of. And then also dogs. I've actually done a couple of agreements where the dog is the influencer and clients have hired dogs to promote their products on social media. So it's a whole new world out there with that. So really anyone who has influence is who we're talking about today. So main concept here is disclosure is key. Your influencers need to disclose clearly and conspicuously their relationship with the brand. If you take away nothing else from the session today, take away what's on this slide, that disclosure is key.
So that leads us over to our next question, which is, what is an endorsement? I'm not going to bore everyone by just kind of reading the CFR definition of it, but broadly, the FTC defines an endorsement as any type of advertising that includes a verbal statement, demonstration, or a depiction of a name, signature, or likeness that essentially a reasonable consumer would believe that it reflects the opinions, findings, or experience of a party other than the sponsoring advertiser or brand. And broadly, these endorsements, which are endorsements and testimonials under the FTC guidelines, are generally treated to be the same, have to reflect the honest opinions, beliefs, and experience of the endorser. And so now the more but practically speaking, what does that mean? So the easiest example would be, if I were to stop in the middle of this presentation and shamelessly plug some sort of Dorsey product that I was trying to get everyone here to sell, but they get more difficult than that. And so kind of more difficult question is, if we have a social media advertisement for, let's say, a particular brand of golf balls, and it shows, let's say it's an Instagram story or something, and it shows a prominent and well-recognized golfer. There's nothing said, but the golfer is practicing drives off the tee and the golf balls are identifiable. Would that be an endorsement? And under the FTC's guidelines, that would be an endorsement, even though there isn't necessarily a verbal statement made. And in such cases, what we need to have is a disclosure when there's any sort of material connection, which, go to the next slide. So what is basically a material connection? The basic rule, essentially, again, I'm not going to bore everyone by kind of reading the long CFR definition, but in a nutshell, if there's a connection between an endorser and a marketer or brand, that consumers would not necessarily expect, and it would somehow impact how a consumer would evaluate that particular endorsement, that connection needs to be disclosed, which then leads to our next question, which is, what is a material connection? And so we have a bunch of examples up on our presentation, which kind of runs through, the obvious ones. Obviously, a payment would be a material connection. Providing free products or services in exchange with an endorsement would also be a material connection. Coupons, let's say you have, say, a smaller influencer who's getting exposure to a bigger brand based on that actual endorsement, that could certainly also be a material connection. It could include an employment relationship, even a personal or family relationship. And so the real takeaway is that essentially anything of value that would or could affect an endorser's opinion would need to be disclosed. And then the reasoning for this is fairly obvious, which is just knowing about the connection would be important for consumers to evaluate it. And I'll turn that back to Fara.
Yeah, so why disclose? Beyond the legal requirements, put yourself in the shoes of the consumer. Someone tells you about a great product. They've been paid to tout this product. Wouldn't you want to know about that connection when you're evaluating the recommendation, the glowing recommendation from this person? And beyond that, brands are responsible for the advertising statements and claims that are made by their influencers. So an influencer cannot say something that a company can't say itself. Our recommendation for all of this is to do your homework before hiring an influencer. Look at their accounts, feeds, mentions, comments, not just the channel that you're interested in, but all of it. If they're working for other brands, look at the work they're doing for those brands. Are they following disclosure rules? Are they intentionally hiding connections? Are they sophisticated? You can learn a lot about the person you've hired to endorse your products by looking at the work that they're already doing for others who are in similar positions. And then, there's a different level of diligence required. I shouldn't say required, that a company might want to undertake depending on circumstances, right? Some level of diligence is a good idea, but the exact level may depend on risk tolerance and other issues. Fara was telling me recently that one of her clients was doing background checks on influencers. That's pretty high level of diligence, but might be warranted in some circumstances, I think. So let's talk about a hypo. So, and this is to sort of get at the how and the where of disclosures. So here's our hypo. Dorsey, pandemic times, legal work is down. We pivot quickly. We make a sports drink. We've decided we're going to get to consumer products, food and beverage. So sports drink's awesome. We need an influencer to promote the drink. We hire someone. Our legal and marketing team is now looking at what they need to do to be able to promote this with their influencer in a legal way. So Fara, can you tell us how we would disclose?
Sure. So, as Charlene said, we're going to talk about how to disclose, and we're going to use our hypo, the Dorsey drink, to help us see how we're going to make these disclosures. So, cardinal rule is clear and unambiguous disclosure. You do not have to use hashtags, but on social media, they're so easy to use. Hashtag ad is the easiest one to use, but a lot of brands don't like it. A lot of influencers don't like it. They think it's sort of cold and harsh and not natural. I think that everybody's focused on authenticity on social media. And so, there are other words, there's other language that you can use. The Federal Trade Commission has specifically said using the brand, hashtag the brand or the product partner is a great one. So here, hashtag Dorsey drink partner. Hashtag sponsored is also another great option. Hashtag Dorsey drink ambassador or free merchandise. If the person got free merchandise, that's what that's how they can disclose it. We've specifically been told by the Federal Trade Commission, do not use hashtag spawn, SP, or just ambassador by itself. If there's a post out there and you see somebody drinking a sports drink and saying, wow, this is a great drink, and then in the comments it says hashtag ambassador, I don't really know what that necessarily means. It might mean that you're a brand ambassador, but it might mean something else. A more specific guidance, thanking the brand is not enough, because you could just be buying a product and say, wow, thanks brand, this is a really great drink. I don't know that that means that the brand paid you a bunch of money to include them on your social media channel. So it's really important to make your disclosure unambiguous. And again, tagging the brand isn't enough, because I can tag the brand if I'm unrelated to the brand as well. So I think next slide, Charlene.
Hey, Fara, but so like,
Yeah.
I can't just use hashtag partner. I have to, I mean, that's not enough. We don't, right?
No, it's still ambiguous. I mean, what does hashtag partner mean anyways? It's quite unclear. And sometimes people use hashtags for various reasons. Some of them are unclear, some of them are clear,
Right.
but partner doesn't really mean all that much without a direct link to the brand. And also, one thing to note, there are a lot of companies out there that sell products, and we're only familiar as consumers with the name of the product. We're not really familiar with the name of the company that sells the products. And so sometimes saying hashtag the name of the company wouldn't actually be that great to put in as the identifier with the word partner. You really need the name of the product, because some people don't know where the product comes from.
And I think, Farah, the other thing, and I'm spending a little more time on this slide because it's pretty important, but you wouldn't mix the disclosure into like a bunch of hashtags or a bunch of links. I think that's one of the things that the FTC has said is not great, because it's not clear and conspicuous if it's buried in a sort of litany of other things. Does that make sense?
Yeah, I think that sort of the gold standard best practice is to do it, separate from a bunch of other hashtags, and really upfront at the post. If you want to be entirely unambiguous and clear, you could say hashtag ad is the first three letters in your post if you're posting on Instagram, for example, and there would be no confusion about it.
Yeah.
So that flows nicely into where do you disclose? You should make your disclosure as close as possible to the content which it relates to. So on social media, that most often means putting it in the comments of your post and keeping it close to the post. You also need to have it so it travels with the post. There's a lot of social sharing buttons on other websites. This also applies on blogs and things like that. When you press those social sharing buttons, they do need to come up and show you that this post, this video, what have you, is sponsored. Kind of linking to what Charlene just said, not after a string of hashtags. Because if you're saying, hashtag this, hashtag that, and then buried in the middle or at the very end it says hashtag sponsored, I'm probably not reading all those hashtags. Actually, I'm never reading all those hashtags. So having it up front in a place where folks can see it is super important. I think that, it's been interesting since the Federal Trade Commission really came out with this type of guidance, and it's been, part of the industry. At the very beginning, I think there was a lot of backlash by influencers and by brands. Everybody really wanted to kind of they thought they were making authentic content, but that was sponsored, but they didn't really want to disclose it. They thought that they were sort of being able to fly under the radar. But I think that tide has really changed in the last, say, 2-3 years. If you work with, well-established influencers, if you work with well-established brands, everybody knows that you have to do this, and nobody's really fighting against it anymore. I think there was, when it first came out, people fought against it, and now I think everybody has accepted that these are the rules and this is what we are doing.
Yeah. I think there was a period of time, I feel like, when people really didn't think, that this was advertising. They really didn't they looked at it as some other type of thing. I mean, clearly the influencer and the brand thought it was advertising, but there was this idea that it was some sort of morphed content, where the rules didn't apply. And I think it's really clear now, and everyone, like you said, there's a lot of acceptance around the requirements.
Yeah. Another important note here is that, on a lot of social media platforms, Instagram, for example, there are built-in social media tools. And a couple of years ago, the Federal Trade Commission specifically said that built-in tools are not enough. I personally think that they're some of the disclosure using those tools is actually pretty, appealing, and it's pretty obvious. I think that, that quote unquote rule may change. Nobody's really tested that sort of opinion from the Federal Trade Commission from a couple of years ago in an enforcement action or anything like that. So we don't really know how they would react if somebody said, well, I've been doing this, I think that it's okay. And the sort of talk in the industry is that when the Federal Trade Commission comes out with a new guidance, which I think is supposed to come out this year, they're probably going to say that those things are okay. I mean, we got to wait and see what they say, but currently their specific guidance says that they are not enough. So belt and suspenders, if you want to do those, use them, but I still would throw a hashtag in the comments. So here we have our influencer extraordinaire promoting the Dorsey.
She looks familiar.
I mean, she looks great. I don't know. Promoting the Dorsey drink, fueled up before the playoffs with @Dorsey drink, hashtag sponsored. Great post. As you can see, a lot of likes. That's really, really a great marketing post for the Dorsey drink. And the influencer there with two friends at a football game looks fantastic. Looks like a great post for our brand. An important note is that the hashtag sponsored appeared in the first 3 lines of the Instagram post. So it's what's known as above the fold. For those of you who are familiar with Instagram, when you scroll through Instagram on your phone, especially, which is really how most people use Instagram, you can see that it often has ... more if the comments are pretty long. Those things are hidden if you don't actually press on more. And so you'll never see what's behind there as to the way most people actually use Instagram. So if you put if your influencer puts their disclosure behind the more or below the fold is what it's called as an analogy to newspapers, if anybody actually still reads paper newspapers, that's hidden from view. And so you need to keep it within the first 3 lines.
Fara, I think we actually have a question. Someone asked, is there any concern that a hashtag brand partner creates a risk of an influencer being authorized to bind or otherwise represent the brand as a legal partner or agent?
That is a great question. I've not actually considered that issue before. I think it would be very context specific as to the context of what you're trying to bind them and what you're doing. It's a pretty commonly used hashtag with partner, and it's been sort of suggested by the FTC that this is a good one to use. And so I think it's unlikely that fact alone would allow you to sort of say in any court that this is an agent of the company.
Mm-hmm.
Anybody else want to add something?
Oh. Charlene?
No, go ahead, Tim. Yeah.
I was going to say, we actually have one more as well,
Yeah.
asking about whether the tool built into Instagram where a post can be noted to be a paid partnership, whether that's enough. I'm thinking that means whether that's enough in absence of a hashtag.
Yeah, so currently, I think that unfortunately, the Federal Trade Commission has said a couple years ago that it's not enough. Like I said before, I think they are going to change their mind on that. But if you want to be completely in the clear, I think the gold standard advice is to use a hashtag as well. So let's talk about videos. Same rules apply. Think about how long your video is up on the screen. If you're using Instagram stories, if you're using TikTok, for example, you have to think about how to do the disclosure effectively. think about font size, think about color. These rules apply, sort of from the old school rules of television commercials to having tiny little gray mice type on a white background. No one can read that. Not going to happen. Instagram stories, how many of you watch Instagram stories with the sound on? I never do. Even if I'm sitting in my apartment alone by myself, I don't have the volume up. Even if it says volume up, I probably never turn it up. So having them spoken is probably not an effective way to make a disclosure on an Instagram story. Having it on the screen and having it on the screen long enough so people can read it is super important.
All right, let's move to our first poll. Which hashtag works? The first one, hashtag ad. Second, hashtag paid. Third, hashtag partner. Fourth, both A and B. Fifth, all of the above. We'll give you just a couple of more seconds to answer. I can do like the Jeopardy tune or something. All right, let's see the answers. Oh, 18% said hashtag ad, 50% said both A and B. If you were one of those 50%, you are right. All right, I just need to close this, sorry. Great, moving on. All right, Tim, take it away. Thank you, sorry to interrupt.
No, please, not at all. So we're now going to talk about basically what happens if you don't follow this advice. So as part of the FTC's regulatory and kind of consumer protection authority, the FTC is authorized to regulate, among other things, social media. And while basically the range of laws that they have in terms of their law enforcement and administrative responsibilities can in some cases be dated, the FTC is very good at kind of pivoting. And so in April of actually this past year, the Supreme Court had actually ruled in AMG Capital Management that the FTC could not rely on one portion of the FTC Act in terms of obtaining monetary restitution. And as a result of that, they have since pivoted to other potential sections, which I think we'll talk about a little bit later. But the takeaway from this is really that they will apply older laws to newer and novel concepts, which brings us to Devumi. Which for Devumi was actually a precedent kind of setting enforcement action for the FTC, as well as there were a number of state attorney generals that were also involved. And essentially Devumi made millions. It actually at the time made a ton of news because it turned out that Devumi sold fake followers, retweets, likes, subscribers, views, anything that you can possibly think of that it was indicative of like fake social clout. And it turned out to involve a number of very, very popular musicians, athletes, politicians, celebrities. All these people ended up having these fake followers, not necessarily purchasing them, but they basically had sort of gotten swept up into their follower accounts. And so at one point, Devumi had operated a stock of at least, I think it was over 3 million automated bots. And the FTC, I think it was Florida, and as well as New York state attorney generals, had essentially sued to stop that. And the FTC alleged that essentially by distributing these fake indicators of source and social media influence, they had, I want to quote their exact language, they had provided their customers with the means and instrumentalities to commit deceptive acts or practices, which is itself a deceptive act or practice in violation of the FTC Act. The parties eventually settled for a multi-million-dollar settlement between all of them. And it ended up being one of the first in the country actions in which a regulatory body and state attorney generals were actually going after these fake followers and fake likes. The company has since gone out of business, but it is a pretty good example of the FTC's ability to kind of pivot into new technology and be able to adapt to newer social media and kind of the advent of technology. With the takeaway being that under the FTC endorsement guides, a like from a non-existent person or a person who has no experience using the product is deceptive, as is purchasing and selling those, the actual purveyor of those fake accounts. which then leads us to another example of the FTC's enforcement activity, which is in the matter of Sunday Riley. Sunday Riley was a cosmetics company. And so early, and I think it was 2019 or 2016, Sunday Riley and kind of upper management had directed their employees to begin posting fake reviews on Sephora.com. And the FTC complaint actually quotes emails from Ms. Riley directing each of them to create 3 accounts on Sephora.com and actually include step-by-step instructions on how to essentially set up new personas and avoid being caught. And at one point advised them to always leave 5 stars when reviewing Sunday Riley skincare products and to intentionally dislike negative reviews, because if you disliked enough of them, it was removed, which in turn would translate into sales. And so unsurprisingly, the FTC charged Sunday Riley and the company with deceiving consumers about the material connections between the company. And the FTC and Sunday Riley eventually settled with a no money, no fault order, but they were essentially banned from ever engaging in that kind of practice or behavior again. And the takeaway here, which should theoretically be obvious, but you cannot have employees posing as customers who are essentially providing disguised reviews. That would be itself a failure to disclose a material connection.
Excellent. Thanks, Tim. So more about employees. Material connection, if they make statements on social media, they have to disclose their connection to the company. Tim's a great case filled with lots of landmines. What happened there? So here's a post by Employee of the Month. I'm not a dog, or am I? I'm so excited to announce that my company released hashtag Dorsey drink in time for hashtag the big game. So this looks pretty good. We have a disclosure here. My company, we're an employee. We used the hashtag big game instead of Super Bowl, which keeps us out of trademark trouble, which we will see later. There's no wild health claims in this particular post, like they might have been like earlier with the leg cramps. And of course, we're assuming this, and well, we're not even assuming this employee didn't make a claim about how fantastic the drink tastes, having never tried it, or maybe if it really just does taste terrible because Dorsey's in the legal industry and not in the drink industry. So this one looks pretty good. Let's take a poll. Is the company responsible for monitoring employee social posts? Yes or no? All right, we'll just give it another second here. All right, let's see the answers. 56% yes, 44% no. This is a great split because it's a little bit of a trick question. And Fara and I were discussing this earlier because it's a tricky question. So, so you don't have to monitor everything. I think that's the answer. Yes, there's some duty to have a policy to monitor, maybe a heightened duty in some circumstances, I'll talk about in a second. But I think the sum total, let me flip to this next slide, sorry, is that you don't have to monitor everything, but it's not black and white. So the key is to have a policy and to enforce that policy. It's unreasonable, says the FTC in these endorsement guides, what people are asking question and answers, to monitor all employee posts. I think we can all agree on that. Maybe if it's just you at the company, it's not unreasonable, but if you have more than several, it would be. But the company should establish a policy and have a program, a program to remind employees that the policy exists, a program to remind employees how they comply with that policy and how they comply with the rules. And then I think if you're actively asking employees to post something or to promote something, you know, in that circumstance, you probably do have a heightened obligation to randomly monitor or to monitor those posts because you're making a specific request that employees do this. And then of course, if the company learns of a post that doesn't meet the legal requirements, the company policy, repeat offenders, things like that, the company does need to take action to fix that post, to retrain that employer, to perhaps ask them to stop posting if they're, you know, maybe a repeat offender. In a couple of slides here, I think Fara, you're going to take us through some practical tips for monitoring posts.
Yeah. So before we get there, we'll
Yeah.
we'll go back and we'll talk about another Federal Trade Commission enforcement action. So you can flip to the next slide.
Yep, sorry.
That's okay. So TIMI, Federal Trade Commission, did an enforcement action against TIMI. TIMI is a diet drink, I believe, and they also had some skincare issues. And so they hired a ton of influencers to promote the brand. One of those influencers is Cardi B. And they also, hired a bunch of other smaller, lower level influencers who still have decent followings. This complaint was really instructive and really great for, us lawyers, because we really got to see the Federal Trade Commission apply their regulations and their guidance in practice. In this specific one, they brought an action against TIMI, and somebody had asked in the Q&A if we could talk about the allocation of risk between brand and influencer and how much responsibility brands have to police influencers. And so we're going to talk about monitoring a little bit, so that directly responds to the policing. But between brands and influencers, brands are primarily responsible. It's your product, it's your brand, it's your advertising, and you are either paying or you're providing products or services to these influencers in order to promote your brand. And so ultimately you are responsible for their actions. Can they do what they want without, with immunity? No, they can't. The Federal Trade Commission has started cracking down on influencers as well. In this particular case, they sent out a bunch of warning letters to a bunch of influencers who were part of this campaign, one of them being Cardi B. So in this case, some of the influencers were using disclosures. They were using, TIMI partner, as we can see. But remember, we talked about this before, it needs to be in the first 3 lines because it's going to be below the fold in this case. Cardi B's specific post here, I don't think had the right hashtags in the right places either. And so, the Federal Trade Commission sent notifications to the influencers and said, hey guys, you gotta fix this, because they're also promoting a brand. They're promoting their personal brands. And so it's part of advertising, and the Federal Trade Commission thinks it's deceptive. So next slide, Charlene. So in October of 2021, the Federal Trade Commission sent out a notification to 700 major advertisers, including retailers, consumer product companies, ad agencies were included as well. They basically, papered the industry with these notices saying, we're putting you guys on notice. Fake consumer reviews have to stop. We don't want misleading endorsements, and they're not going to be tolerated. We have the power to impose fines, and I actually don't quite specifically know where this 43,000 number comes from. It's very specific, somewhere in the statute, and it's increased by inflation and et cetera. It's not necessarily super important, but they can do that per violation. And they sent out all these letters, so everybody is on notice. Just because you got a letter doesn't mean that you were doing something wrong. And just because you didn't get a letter doesn't mean that you weren't doing anything wrong. But it's a blanket notice to everyone, stop doing this. And we are going to be making some fines in this current year. And I think they are going to, I think it's not just a threat. I kind of think it is a promise. We will see. They included sort of a don't do's in their, in those letters. And I'm not going to read all of these, but really the main theme here is that folks are not disclosing material connections. And one of the hot topics for the FTC lately has been reviews. They care about fake reviews, obviously, as Tim talked about. They care about reviews that are not being disclosed properly when there are endorsements. And they really are coming down on this. Just this past week, or just this week, actually, they announced a settlement with a company that was helping brands suppress low-star reviews and said, this is deceptive, because if you go on a website and you need to look at the reviews of a specific product at the, at the Dorsey store, and you're looking at the Dorsey drink, and you're looking at the, diet raspberry flavor, and it pushes all the 5-star reviews to the top and it pushes all the 1-star reviews to the bottom, I think it's a really great product that has no issues with it. And I think that it's not really going to taste, salty, but there are a bunch of low-level reviews that say it tastes salty, but I'm never going to see those because they've been suppressed. And things like that is what the Federal Trade Commission is talking about. So we are going to make this presentation available afterwards. And so, or maybe it actually is available right now too, if you want to download it. And so I pay attention to this list. It's super important.
Yeah, and I think, Fara, some of this is the same as it's always been, right? Disclosure, don't make false claims, unsubstantiated claims. It applies to traditional advertising too. It's just a different medium. And there's some very specific rules, right, that you've been talking about to follow, but disclosure is key, false, fair, all of it, all still applies. So it's not much different than it used to be. It's just a different medium, it seems.
Yeah, so circling back to monitoring. So how much do brands have to monitor? The Federal Trade Commission has said specifically, it's unrealistic for you guys brands, to have to monitor every single post of every single influencer if you have a large sort of bevy of influencers. So what are you supposed to do? How are you supposed to make sure that your influencers are doing the right thing? And not spend all of your time monitoring them. So periodic checks are great. Make sure that you keep records that you've actually checked up on your influencers. Take screenshots, make logs, set aside an hour a month, depending on how many you have, or maybe it's a couple minutes a week. It sort of depends. Everything depends here on the scope of your influencer program, but make it reasonable. Start at the beginning with having a set of guidelines that is very specific to your company, to your industry, to the type of influencers you are working with. And Tim's going to talk about some of that stuff a little later when we talk about contracts for influencers. But it starts with the contracts, and then it goes on to training if necessary, and then it goes on to monitoring. Do periodic checks. If you find habitual, non-compliant influencers, you need to consider terminating them. You need to tell them in their contracts, we take this stuff seriously. We want you to follow it. Please pay attention, and we will be watching. And if you mess up every now and then, it's not that big of a deal. It can be an aberration, but you do need to pay attention to this stuff, and it is very important. There have been Federal Trade Commission cases where the FTC has actually put in a closing letter and said to certain entities in enforcement action, okay, this was an aberration. You guys had a set of guidelines, you had a set of practices and procedures, and the ones that we caught, those were actually mistakes, honest to goodness mistakes, and you do have procedures in place to prevent this from happening. They're not bulletproof. It's not about strict liability, but something fell through the cracks here, and that's okay. And so the Federal Trade Commission is actually very reasonable in that way in this space, because they are not agents of the company. They are, contractors, and you don't have complete control over them, but you should have a measured amount of control over them.
Fara, we just had a question come in. Are you familiar with platforms or services for monitoring influencer posts?
I'm sure there probably are some services out there. People can make a service out of almost anything these days. I think there's a market for it. So there probably are. I don't actually know of any off the top of my head. However, if you do outsource it to, say, your ad agency or your lawyers, for example, it doesn't absolve you of the responsibility. That it doesn't say, okay, fine, you let somebody else take care of it. You thought they were doing a great job and it's fine. You need to actually have reports from that party who is monitoring for you and have them check in and give you, you know, a quarterly report, a monthly report, something like that, and say, hey guys, this is what we found. Should we do X, Y, Z? Should we terminate this person? Should we give notices? Should we have them pull back posts? Things like that. So it's not something that can be completely outsourced, but you can give somebody sort of the bulk of the work and say, hey, we don't have the time to spend monitoring posts individual, but, you know, do it for us and then come back to us and we'll deal with the important ones.
Good to know. So I'm going to talk a little bit about influencer contracts and kind of key terms that you want to focus on. So in terms of what I identified here, payments, exclusivity, approval rights, morals clauses, force majeure, and then indemnification. This is, of course, not all of the important clauses, but otherwise we'd end up running out of time. So one potential kind of practical tip is in terms of payments is actually setting up the payment structure in such a way that each separate act, for example, if you have multiple posts or multiple activities, that each one is on its own payment, and so you're not necessarily prepaying for say 3 posts, and you're paying basically contingent upon performance essentially. And then on top of that, if approval is vital, especially of these posts or social engagement, which presumably approval will be vital in most agreements. You'd want to ensure that no fee is necessarily paid out or is due until after the post is actually approved. So you don't necessarily have to end up paying out for, say, an unapproved post that theoretically could end up getting you into hot water. In terms of exclusivity, that would be something that you'd want to consider in terms of the brand kind of either doesn't want a particular influencer to, you know, go 2 days later and you suddenly see that your influencer you just engaged for a $20 million massive social blanketing campaign is suddenly also signed up and promoting a competing product directly to yours. That would obviously not be particularly desirable. So that's an area that you can also cover in terms of your influencer contracts. Typically, the exclusivity language would include some sort of categorization for the branding, as well as kind of an identifiable list of potential competitors, as well as in certain cases, posting time and geographic restrictions. Approval rights is also going to be a very, very important aspect, specifically for retaining those rights for the brand. Typically, what that would do is that would provide the ability to approve content, edit, reshoots, cut down, almost anything in advance of posting. That would be something that the brand would necessarily want to keep and hold on to. And the brand or advertiser should really have the ability to review and approve that content before it goes up. And the best kind of practice tip would be to have basically the approval and in general, the process articulated in an agreement or a statement of work for how exactly that would work out in the case of, say, if, you know, there has to be a reshoot or a re-edit or something has to be swapped in and out, because you don't want to necessarily have a contract in place, have to basically, you know, re-edit something out and then end up in a situation where you don't have a process or procedure. That would also typically, you'd want to also have approval rights over particular types of content, you know, preventing it from including any sort of nudity, sexually explicit content, anything like that, reference to drugs. And on top of that, as I'll talk about, I think in a slide later, there's also IP and ownership implications that go along with approval rights. The morals clause is also becoming a much bigger deal nowadays. Generally speaking, it prohibits certain behavior in connection with an influencer's public or private life. But what we're seeing now is that these provisions are actually becoming more or less reciprocal. So in the past, it would primarily be, you know, the advertiser would want it. So if the influencer does something, you'd be covered and you could terminate the agreement. However, what we're seeing now is as the power dynamic is more or less shifting with influencers, they're now able and have the ability to kind of push a morals clause of sorts on the advertisers and brands in, you know, whether it's a true morals clause or whether it's, you know, they really only want to push sustainable products or something similar. That is, from what we've seen, kind of a newer trend. And then going along with that, and what Fara mentioned earlier, it's also very important to have a monitoring plan in place in connection with the morals clause as well. Also relevant, especially in light of the last 2 or 3 years that we've had.
Wherever we are.
Yeah, I don't even know anymore, but force majeure language, and specifically what we've now probably all found out is that it's often helpful to include language that would apply to, I should go back a step, but the force majeure language would provide for termination or suspension of a party's obligations where an act beyond that party's control arises. So one particular aspect that has become especially important is, the typical examples would be a flood, fire, earthquake, but also including pandemic language, and then on top of that, government order or law, essentially, which is what happened in a lot of, especially in California, where places were actually shut down and they were unable to even complete any of these contracts, essentially. And then finally, we have indemnification, which, as we've already gone into, the brand is always going to be responsible. You cannot basically push off to an influencer to say things the brand otherwise couldn't say directly. And so while you can essentially split, while you can push off some liability onto the influencer, that, your indemnification is really only worth however much the influencer is. So if it's a relatively small influencer, it really is only, it's only gonna, it still won't help you essentially if you're facing very steep fines. And so for the, I believe our next aspect is IP ownership. And so generally speaking, what we're seeing right now is that obviously both parties want to essentially own their own intellectual property. However, lately, influencers, the trend now is that influencers will actually want to and are actually seeking ownership of the content that they have actually created. And it's important to make sure that you're considering language that will outline in somewhat significant detail the respective ownership rights of each party's names, logos, other trademark concerns. And then it's also very important to make sure that you have reps and warranties governing non-infringement and any sort of third-party rights if that is included in the content. And then moving on finally to FTC compliance. So that is a highly, as I think we've already kind of touched upon it a few times. I think Fara gave a great discussion on it, so I won't rehash it too much, but the best practice, especially for these types of agreements, is really to have basically a standard set of terms with what the influencer should do, what they can't do, and to actually have that affixed in the contract, whether it's an Exhibit A or something similar. But it should really, providing training is also a very good recommendation. And in some cases early on, you could even pre-screen and monitor some of the postings. You should also have reps and warranties that will apply to the influencer that will essentially make it an obligation on their behalf that they are properly disclosing and complying with FTC rules. And so with that, I think we're going back to UGC content.
Great. Thanks, Tim. So we talked about paid influencers, employees, but what about just user-generated content, fan content, essentially? So let's go back to our Dorsey drink hypo here. This is your average consumer. Loving the new hashtag Dorsey drink. It cured my leg cramps. Maybe at 49ers should try this out for the Super Bowl. Okay, let's do another poll. What do you guys think? Should we retweet this?
So Charlene, in the interest of time, I think that we're gonna skip the poll process of this, and maybe we'll talk it through ourselves. So if you want to just go back one slide and we can put it up on the screen and we can just talk about it for a second.
Sure. Yeah. So So here we have a lot of issues, right? So we have an average consumer who's saying it cured leg cramps. So we have an unsubstantiated health claim here. We're also using 49ers and Super Bowl. So we have some trademark issues. This is probably one we shouldn't retweet, probably one we should leave alone. There's a lot of issues with this tweet. The employee tweet earlier that we saw, much better. Fara, did you want to say more on this? I'm conscious of the time.
Yeah, just quickly, it has those health claims in it that we don't like as a company, but the Federal Trade Commission and the regulators are not going to come after Dorsey because some consumer thinks that they cured, that we've cured their leg cramps. We're not promoting this. We're not liking it. We're not going to do anything to it. We're not going to respond, and we're just going to leave it there. It's not our message. We didn't pay this average consumer, and so it's fine. It's just out there, and we don't have any obligation to do anything about it.
Right, but we're certainly not going to like it. We're not going to retweet it.
Correct.
Yeah. Perfect. So what can you do with user-generated content? So we have a list here on the screen: potential actions: retweet, share, like, respond, post it on the brand social channels or elsewhere. But before you do that, you need to consider all of these different issues. And Tim on a slide here after me is going to get into these a little bit more specifically. But if there's unsubstantiated claims or health claims, like we just saw with the leg cramps, or other things in a post, you want to consider that. Should you be retweeting it? Should you leave it? Trademark and copyright issues. Super Bowl, we saw in the last tweet, there's a trademark issue. Copyright, if it's a photo like the one you see on this slide here, someone took that photo, they own that photo. If there's identifiable people in that photo, maybe a celebrity, we have rights of publicity issues. So the safest thing, if you want to repost something on your channel or use it, is to send someone a DM and see if they mind if you use it. It clears some of these issues, at least maybe the copyright in the picture, or maybe if they're the person in the picture. You could also post a comment under the user-generated content with a request for permission to use. I know, I remember a case actually from several years ago now. Krogh had a process of doing this, and it was missed at some point and became a case, but of asking consumers if they could use the content when they would post themselves doing really fun stuff with their families wearing the product, which is really cool. So that's another great way to get permission. So Tim, why don't you take us through some of the issues a little bit more closely that I talked about in this slide?
Sure. So you've done a great job of summarizing all those issues in UGC, and all of those same things pop up when dealing with celebrities. And similarly to what you had mentioned earlier about just getting permission, the basic rule for interacting with celebrities, at least in this context, and the easiest and most safest way to do it would just be to wait until the celebrity reaches out or initiates the contact, or either get some sort of permission, because as we'll see in the next two cases and disputes, it's even kind of with the best intentions, you can end up in a situation where you suddenly find yourself subject to a lawsuit. And so one of the more popular and well-known cases is so it's Jordan v. Jewel Foods. There was also a parallel case with Dominick's. And so in 2009, when NBA legend Michael Jordan was inducted into the NBA Hall of Fame, Sports Illustrated created a special commemorative issue and offered both Jewel Osco and Dominick's Foods. Both of them were Chicago area grocery store food chains. Essentially free space inside of this commemorative issue, as long as Jewel and Dominick's agreed to actually stock the issue. And so Jewel, not one to wanting to celebrate a local legend, put in a notice, I guess we can call it a notice or an ad, that basically featured their logo, a pair of basketball sneakers bearing Jordan's number, and then a short paragraph congratulating Jordan. It's on the current slide. I don't want to read and take up too much time, but safe to say that given everything on that, when Michael Jordan saw it, he, while it was a nice congratulatory note, also saw that it sort of looked a little bit like a royalty-free advertisement. And unsurprisingly, he brought a Lanham Act false endorsement claim. And so Jewel, in response, argued that basically they were immune under the First Amendment and it was fully protected non-commercial speech. The district court actually had sided with Jewel, and then when it got up to the Seventh Circuit, they had actually reversed and found that, amid the celebratory applause on the occasion of Michael Jordan's elevation to the Hall of Fame, Jewel's notice had an unmistakable commercial function, which enhancing the Jewel brand in the minds of consumers. And so although it was implicit and easily inferred, the ad was actually the dominant message. And even though the ad didn't necessarily invite consumers, as you'll notice, to buy a specific product, it still proposed a commercial transaction. And the court basically found that it implicitly encouraged consumers to patronize their local Jewel-Osco store. And so as you'll see, a jury awarded Jordan $8.9 million in one of the cases, and the other actually settled for an undisclosed amount. And then more recently, which may now be still in some people's minds here. So in 2014, Katherine Heigl was actually photographed leaving a Duane Reade store in New York, carrying 2 Duane Reade bags. And a very alert and attentive Duane Reade social media employee saw the photo, and I think it was actually available on a kind of celebrity, I guess, news page, and had tweeted out the photo and actually said, "Love a quick Duane Reade run? Even Katherine Heigl can't resist shopping at New York City's favorite drugstore." They did not have Katherine Heigl's permission, or there was, as far as we're aware, no real conversations between them before that. And so unsurprisingly, Katherine Heigl filed a lawsuit. Her complaint alleged that they had engaged in unauthorized use of her name and likeness in connection with its advertisement of its own services. And it, in turn, violated her right of publicity and privacy under New York state law. She had actually sought $6 million in damages, which, to be fair, were actually going to go towards a foundation for her deceased brother, but the parties ended up actually settling for an undisclosed amount, which we will not know. And then I will turn off to, I think, memes and how to do them right.
Yeah, we'll float through this quickly because I think the last slide that Fara is going to do will be pretty interesting to people, and we only have a few minutes. But use of a meme on a branded Twitter account is advertising. This is a couple of slides on how to do them right, and then maybe one on a missed opportunity. But I think the takeaway for these is really the more creatively you think, the more likely you are to avoid sort of these copyright, publicity, endorsement issues we've been talking about. So here's one that was great by Kit Kat, related to the Muppets Most Wanted movie. Me, I should save some for later. Me to me, it is later. You can see the imagery here. So that's a nice example of a meme done right. Another one, everybody loves Bernie Sanders at the inauguration with the mittens, looking very, low key in his jacket, and Etsy capitalizes on this trending public event. Heard people were looking for some mittens with little posted mittens. Another great meme. And then here's one that's kind of a juxtaposition to the others. It's and Fara, you have some feelings about this, but like it's a missed opportunity here. So this is Pippa at the royal wedding in a dress that bears a striking resemblance to the Arizona tea can. And Arizona Tea says, "Pippa got you feeling thirsty." Great post, but we're creating issues of publicity here, maybe an endorsement by Pippa, maybe some issue that could have been raised, don't know that it was. But Fara, you had an interesting idea of what might have been a more creative way to do this.
Yeah, I mean, they could have just shown the Arizona can and cut it into the shape of a dress and popped a little hat on it. And I think on that particular morning, everyone would have known what they were talking about on Twitter, and it would have been cute. It would have been hinting, but there would not have been a right of publicity or a copyright issue. Whereas here, there potentially are those issues. And I think it's safer legally if they had been a little bit more creative.
Yeah, and I think that's right. The more creative, the better. And the better they land, oftentimes. So hashtags. Here's a few examples of hashtags that people use often by some of the most, I think, aggressive enforcers of hashtags. So we have the do not use over here and the okays. You guys are going to have these slides. Please take a look at them in your free time. But Super Bowl, don't use it. Use the big game.
So Charlene, it's now 2:00 or in the East Coast and different times other places, but we are at the end of our time. But
Yep.
So if people want to I know people probably have to leave, but if you have a moment to stay on, we're just going to conclude. This is our sort of one last substantive slide, platform tools. Just wanted to make a quick note here. A lot of the social media platforms have built-in tools for memes. For example, on Twitter, there are GIFs from Jiffy or GIFs. I always forget which way you're supposed to pronounce it. There's music on Instagram. There's music on TikTok. Depending on how you set up your brand account, sometimes they are professional accounts. Sometimes you sort of set them up when you're a startup small business and they're not professional accounts, they're not verified accounts, they're just a regular type people accounts. And sometimes your influencers have regular people accounts versus business accounts when they really are business accounts. The way you designate your account gives you access to different types of built-in tools here. But to be clear, when you do go and read the terms of these platforms and the built-in tools, most of the built-in tools are provided for personal and non-commercial purposes. And that means that your branded Twitter account, that's not for your use. Putting up memes with the built-in tools, you have to think twice about that, because there are still the same issues that Tim and Charlene discussed here. Just because the tools are presented to you and the images are available doesn't mean that they're licensed to you for the purpose that you are using them for. TikTok had a lawsuit a couple years ago now from music companies, and they ended up creating on the professional account side a catalog of music, I believe, that's available for professional accounts only, and so it's all licensed. And so you're in the clear if you have a properly designated account and you're using the tools that are for you on different platforms. So it's definitely something to think about. And then we have one more last slide here. Just some FTC resources. The guides that we keep referring to, they were last revised in 2009. They are supposed to be being revised this year. They've had comments and discussions and stuff throughout the pandemic. And so I'm hoping for a new set addressing some of the new issues and updating things like built-in disclosure tools on Instagram, for example. But in the meantime, we have some FAQs that are really helpful. We cite them a bunch in this presentation. I suggest everybody here, when you have questions, go check them out. They have a lot of really great FAQs there, and they're super helpful. And then last item is, if you guys missed part 1 and part 2 of our series, we invite you to watch the playbacks, and you can email us with questions at any time. So wanted to thank everybody for joining, and have a lovely afternoon.
Thanks, everybody.